U.S. visa options for J-1, H-1B, O-1, and T-1. It is well known that constant advances in the field of research depends on an incessant flow of well-trained, capable, and motivated people into the field. The influx of foreign professors and researchers into the U.S. has always assisted in furthering the cause of science and technology, with the added premium of universal welfare. Foreign professors and researchers coming into the U.S. have expanded the community of science and technology, bringing with them the new and innovative ideas. They have assisted the organizations they have come to realize core objectives, and at the same time boosted their own careers. The challenge for professors and researchers, and the universities, research institutions, and companies that seek them out, lies in selecting the appropriate immigration visa options from the various U.S. visas. We will discuss some of the non-immigrant U.S. visa options for professors and researchers below, and we'll address the immigration options later article. Non-immigrant U.S. visa options to work temporarily in the U.S. J-1, H-1B, O-1, and T-1. A J-1 visa. The J-1 is a non-immigrant visa program under which foreign professors and researchers engage in research, teaching, and lecturing with their American colleagues. Alien physicians in graduate medical education or training and short-term scholars are not included in this category. They are covered by a different aspect of the J-1 program. The purpose of the J-1 program. The purpose of the J-1 Exchange Visitor Program, in part, is to foster the exchange of ideas between Americans and foreign nationals and to stimulate international collaborative teaching, lecturing, and research efforts. The exchange of professors and researchers promotes the exchange of ideas, research, mutual enrichment, and linkages between research and educational institutions in the United States and foreign countries. It does so by providing foreign professors and research scholars the opportunity to engage in research, teaching, and lecturing with their American colleagues, to participate actively in cross-cultural activities with Americans, and ultimately to share with their countrymen their experiences and increased knowledge of the U.S. and their substantive fields. Who are eligible as professors and researchers under the J-1 visa program? Professor. An individual engaged primarily in teaching, lecturing, observing, or consulting at post-secondary accredited educational institutions, museums, libraries, or similar types of institution. A professor may also conduct research, unless specifically disallowed by the sponsor. Research scholar. An individual primarily conducting research, observing, or consulting in connection with research project at research institutions, corporate research facilities, museums, libraries, post-secondary accredited educational institutions, or similar types of institutions. The research scholar may also teach or lecture, again, unless specifically disallowed by the sponsor. J-1 eligibility criteria. An individual may be selected for participation in the J-1 Exchange Visitor Program as a professor or research scholar, subject to the following conditions. The participant must not be a candidate for a tenure-track position. The participant has not been physically present in the United States as a non-immigrant for all or part of the 12-month period immediately preceding the date of program commencement as set forth on his or her Form DS-2019, unless the participant is transferring to the sponsor's program, the participant's presence in the United States was less than 6-month duration, or the participant's presence in the United States was pursuant to a short-term scholar exchange activity, and the participant is not subject to the prohibition against repeat participation. Please note, the Form DS-2019, issued by the J-1 sponsor, must be issued only after the professor or research scholar has been accepted by the institution where he or she will participate in an exchange visitor program. Occasional lectures or consultations. Professors and researchers may participate in occasional lectures and short-term consultations, but only if authorized to do so by his or her sponsor. Any such lectures and consultations must be incidental to the exchange visitor's primary program activities. If wages or other remuneration is received by the exchange visitor for such activities, the exchange visitor can act as an independent contractor, and the following criteria and procedures must be satisfied. The occasional lectures or short-term consultations must be directly related to the objectives of the exchange visitors program. They must be incidental to the exchange visitors' primary program activities. There must not be a delay in the completion date of the exchange visitors program, and they must be documented in SEVIS. Obtaining authorization to engage in occasional lectures or short-term consultations involving wages or other remuneration. The exchange visitor must present to the responsible officer a letter from the sponsor setting forth the terms and conditions of the offer to lecture or consult, including the duration, number of hours, field or subject, amount of compensation, and description of such activity, and a letter from the exchange visitor's department head or supervisor recommending such activity and explaining how the activity would enhance the exchange visitors program. Note that the responsible officer must review the letters required and make a written determination whether such activity is warranted, will not interrupt the exchange visitor's original objective, and satisfies the criteria. The duration of the program. A professor or research scholar may be authorized to participate in the exchange visitor program for the length of time necessary to complete his or her program, provided such time does not exceed 5 years. The 5-year period of participation is continuous and begins with the initial program begin date documented in SEVIS or the date such status was acquired via a change of status approved by the Department of Homeland Security, as documented in SEVIS, and ends 5 years from such date. A responsible officer may not extend period duration beyond the 5-year period or maximum program duration authorized for professors and research scholar participants. The State Department may, in its sole discretion, authorize an extension period beyond that initial 5-year period. J-1 visa, 2-year home residence requirement and waivers. Professors and researchers who enter the U.S. in or change their status to J-1 status may be subject to the 2-year foreign residence requirement. If subject to the 2-year home residence requirement, they are ineligible to change their status to that of an H, L, or legal permanent resident status until they have fulfilled the 2-year foreign residence requirement. This can only be done by the professor or researcher going back to their home country or country of last residence. Professors and researchers on J-1 visa status may also apply for a waiver of the 2-year foreign residence requirement if they wish to remain in the United States beyond the end date of their programs, or if they seek to submit an application to the USCIS for a change of visa status. Let's look at a puzzle. A professor entered the U.S. on September 1, 2005. How will the J-1 visa 2-year home country residence requirement affect him? A professor who enters the United States on September 1, 2005 may leave the United States and return several times within the 5 years until August 31, 2010. After August 31, 2010, this individual cannot return to the United States in the professor or research scholar exchange visitor category, or as an H-1, L-1, or immigrant for 2 years, i.e., their program begin date as a J-1 professor or research scholar could not be earlier than September 1, 2012. However, if a professor or researcher has not yet become subject to the 2-year home residence requirement, the strongest possible consideration should be given to J-1 alternatives, such as H-1B, O-1, and other U.S. visa options that do not have the home residence restriction and provide lawful permanent residence options. H-1B specialty occupation visa applicants who have been in the United States previously on a J-1 visa program may be subject to the 2-year foreign residence requirement when applying for an H-1B visa. If they are subject to the residency requirement and the applicant has not yet spent 2 years outside the United States, he or she must obtain a waiver of the 2-year foreign residence requirement before the H-1B can be issued. Let's look at the H-1B visa. The H-1B non-immigrant visa category allows U.S. employers to augment the existing labor force with highly skilled temporary workers from outside the U.S. The H-1B program is utilized by U.S. employers, including many university and research institutions, to employ professionals, including professors and researchers, in specialty occupations that require theoretical or technical expertise in their specialized field. A specialty occupation requires the theoretical and practical application of a body of specialized knowledge and a bachelor's degree or the equivalent in the specific specialty. For example, sciences, medicine, healthcare, education, biotechnology, business specialties. The H-1B visa is not the only visa available for foreign national professors and researchers, but for many, it may be the only visa they qualify for. While the H-1B visas are used primarily for positions in technology and the sciences, they are also available to university and college professors and researchers in various fields. Unfortunately, the current annual cap on the H-1B category is $65,000, a level that has been reached all too early each year. Until the U.S. Congress decides to increase that cap, there will be a fight for the limited number of visas available. Professors and researchers who are employed by universities and certain research institutions generally qualify for H-1B visa status outside of that annual $65,000 cap. Duration of the program. H-1B workers are admitted to the United States for an initial period of up to 3 years, which may be extended for an additional 3 years. A foreign worker can be in H-1B status for a maximum continuous period of 6 years. The employer responsibilities. To hire professors and researchers on H-1B, the job must be a professional position that requires, at a minimum, a bachelor's degree in the field of specialization. Each employer seeking an H-1B has several responsibilities. The employer shall submit a completed labor condition application, or LCA, on Form ETA 9035E in the manner prescribed by the regulations. By completing and signing the LCA, the employer agrees to several attestations regarding an employee's or the employer's responsibilities, including the wages, working conditions, and benefits to be provided to the non-immigrant. The employer shall make the LCA and necessary supporting documentation available for public examination at the employer's principal place of business in the U.S. or the place of employment within 1 working day after the date on which the LCA is filed with the ETA. The employer may then submit a copy of the approved LCA to the U.S. Citizenship and Immigration Services with a completed petition, USCIS Form I-129, requesting H-1B classification. The employer shall not allow the professors or researchers to begin work until USCIS grants the worker authorization to work in the U.S. for that employer, or in the case of a non-immigrant who is already in H-1B status and is changing employment to another employer until the new employer files a petition certified or supported by a certified LCA. The employer shall maintain documentation to meet its burden of proof with respect to the validity of the statements made in its LCA and the accuracy of information provided, in the event that such statement or information is ever challenged. The employer shall also maintain such documentation at its principal place of business in the U.S. and shall make such documentation available to DOL for inspection and copying upon request. While the H-1B visa is certainly a good visa for professors and researchers, its 6-year limit may become or can become a problem for long-term stability. With the shortage of Americans pursuing advanced degrees in many of the science and technical fields, the H-1B visa is a tool needed by U.S. universities and research organizations to fill certain postdoctoral, tenure track, and research positions, including programs funded by the U.S. government. This is particularly true for positions in the sciences and engineering. Unfortunately, professors and researchers in H-1B status must leave after they have reached the 6-year limit, unless the employer begins the permanent residence process for them. Let's now look at the O-1 visa. Under the O-1 non-immigrant visa classification, a U.S. employer, U.S. agent, or a foreign employer through a U.S. agent may petition for professors and researchers who have shown extraordinary ability in the arts, sciences, education, business, or athletics, demonstrated by sustained national or international acclaim, to come to the United States temporarily to continue work in the area of extraordinary ability. Extraordinary ability in the field of science means a level of expertise indicating that the person is one of that small percentage who have risen to the very top of their field of endeavor. The O-1 non-immigrant visa is granted for a specific event, such as a tour, lecture series, or project. An alien may be authorized to come to the United States to perform services relating to an event or events if petitioned by a qualifying employer. Evidentiary criteria. Professors and researchers of extraordinary ability in the fields of science or education must demonstrate sustained national or international acclaim and recognition for achievements in the field of expertise by providing evidence of 1. Receipt of a major internationally recognized award, such as the Nobel Prize, or at least 3 of the following forms of documentation. 1. Documentation of the alien's receipt of nationally or internationally recognized prizes or awards for excellence in the field of endeavor. 2. Documentation of the alien's membership in associations in the field for which classification is sought, which require outstanding achievements of their members, as judged by recognized national or international experts in their disciplines or fields. 3. Published materials in professional or major trade publications, or major media about the alien relating to the alien's work in the field for which classification is sought, which shall include the title, date, and author of such published material and any necessary translation. 4. Evidence of the alien's participation on a panel or individually as a judge of the work of others in the same or an allied field of specialization to that which the classification is sought. 5. Evidence of the alien's original scientific, scholarly, or business-related contributions of major significance in the field. 6. Evidence of the alien's authorship of scholarly articles in the field in professional journals or other major media. 7. Evidence that the alien has been employed in a critical or essential capacity for organizations and establishments that have a distinguished reputation. And 8. Evidence that the alien has either commanded a high salary or will command a high salary or other remuneration for services evidenced by contracts or other reliable evidence. 9. If the criteria do not readily apply to the beneficiary's occupation, the petitioner may submit any comparable evidence in order to establish the beneficiary's eligibility. So let's look at the duration of the program. A petition for O-1 status can be approved for a period of the event, but for no longer than 3 years. The status can be extended in 1-year increments if it is for the same event. If the petition is for a different position with the same employer, or for a new employer, it is considered a new event, and the petition can be granted for up to 3 years. Unlike the H-1B, there is no maximum time that a professor or researcher can be in the U.S. in O-1 status. Professors and researchers may enter the United States up to 10 days before the validity period of the petition begins, and have 10 days after the validity of the petition ends to depart. They may only work, however, during the validity period of that visa. The TN visa. The TN non-immigrant visa is available to citizens of Canada or Mexico to be employed in professional positions in the U.S. as a result of the North America Free Trade Agreement, or NAFTA. TN visas are issued for an initial increment of 3 years and can be extended in 3-year increments. The TN visa, like other non-immigrant visa options discussed above, is given for a specific employer. Any change in employer requires a new petition which must be approved by USCIS before the work can begin with any new employer. How can professors and researchers from Mexico and Canada work in the United States? Professors and researchers from Canada or Mexico may work in the U.S. under the following conditions. The applicant is a citizen of Canada or Mexico. The profession is on the NAFTA list. The position is in the U.S. requires a NAFTA professional. The Mexican or Canadian applicant is to work in a pre-arranged full-time or part-time job for a U.S. employer. Self-employment is not permitted. And professional Canadian or Mexican citizen has the qualifications for the profession. With some exceptions, each profession requires a baccalaureate degree as an entry-level requirement. If a baccalaureate degree is required, experience cannot be substituted for that degree. Some professions have alternative criteria to a bachelor's degree, while some professions require experience in addition to the degree. TN status for Mexican or Canadian citizens can be obtained fairly quickly, but cannot be used for tenured or tenure-track positions, or physicians that engage primarily in the direct treatment of patients. Canadian and Mexican faculty, TNs, are solely for temporary assignments for professors and researchers who are working as teachers or researchers in non-permanent positions. The duration of the program, the maximum period of admission into the U.S. is 3 years. U.S. Citizenship and Immigration Services grants extensions of stay for 3 years at a time. Again, there is no limit on the number of years a TN visa holder can stay in the United States. However, the TN visa status is not for permanent residents. The TN visa holders must be able to show that they continue to have non-immigrant intent. In conclusion, professors and researchers have several options when it comes to temporary entry into the U.S. to teach or conduct research. Each has its benefits and applications, and each have drawbacks. The H-1B allows a person to remain in the U.S. for up to 6 years, but are limited to $65,000 per year. The O-1 is available to only the top individuals in their field, but if a professor or researcher qualifies, they can move to permanent residence fairly easily. The TN is not subject to any caps, but is only available to citizens of Canada and Mexico. The J-1 is a very flexible visa, but often comes with the 2-year home residency requirement. Professors and researchers, their employers, and their legal advisors must carefully weigh all the options against the facts before deciding on which visa to pursue and developing a course of action. Contact Visa Pro if you have any questions regarding any type of business or work visas. Our experienced attorneys will be happy to assist you.